So we are supposed to discuss today articles of association, section 5, that says article. And when we read section 2 clause 5, that article means articles of association. So either you say articles or you can say article of association, it's the same thing. Okay. Now the first question or the first thing that comes in our mind is that what is this articles? Okay, what is this particular thing article? Okay, because we have to submit this document before the registrar of the company while we go for the incorporation of the company. Okay. What is the meaning of article or meaning of articles means that what matters we must write in this particular thing. Okay. So basically, like in the memorandum, all important things we put, like the name, the state where the office will be situated, the object, and the clause 3 of section 4 subsection 1 talk about object. There we missed that object does not mean any object. Object should be as per the section 3. Section 3 of the Companies Act says that a company may be formed for lawful purposes. So here object mean any object, any purpose that is lawful. Okay. For unlawful object you cannot mention in the memorandum. And then the liability clause, then the share capital, etc. Here the general, you can say, regulation for management of the company, like about the board of director, how many director there will be. Yes, there is minimum requirement as per section 149, that minimum 3 director for public company, 2 director for private company, 1 director for 1 person company, then the maximum is 15. But exactly how many directors you want to put in your company, about the general meeting, about the proxies, how they have the voting, about the voting rights. So all other subsidiaries issues that the subscriber want to make it clear at the inception, and they want to they can put all those items under this articles of association or articles. So basically articles is the regulation for management of the company. Whenever there would be any question, the first thing will be check out that whether articles allowing it or not. And with subsequently also, the articles can be altered. Articles has to be seen in light of then the resolutions also. So these are the the method by which the company is governed. But the articles or the regulation you cannot make that would be in contravention of the provision or the rule made under this act or the regulation made, that you cannot make, and the section 6 make it clear. Okay. Now screen I have shared. Please any of you read section 5 subsection 1. Yes, कोई पढ़ो सेक्शन 5 सबसेक्शन 1. Abhishek,
जी sir.
you forget.
Sir, actually I want to give others a chance to read in the class.
Oh my god. Yeah.
ठीक है sir, मैं start करता हूँ sir.
Ranjan is also ready. Okay, Ranjan. Then Ranjan is also a very good student because he has all care. Okay.
रंजन भाई मैं देता हूँ, आप अगला वाला पढ़ दीजिएगा.
ओके, चलो चलो, ओके ओके, यस.
Articles, clause 1. The articles of a company shall contain regulations for management of the company.
Yes. So articles, as we discussed, that articles shall contain the regulation, and it does not prescribe what regulation. Yes, there are some format. The format you will find under the different tables F, G, H, I, J. There you will find certain things like about the voting right, about the proxies, about the directors, about the annual general meeting, etc. The different the management portion, but that is not exclusive, that is just a model. Okay, you can include other matter also. And the section 5 subsection 1 is saying that it shall contain. So shall is only with the management, that the the any regulation, any rules that you want to frame with respect to management, you have to put here. Okay, not other matters. That's the importance of the shall. Then there is another things is come, that is it only the model that provided here under different tables, or can we include something more also? And this thing has been clarified by letter subsection 2, that says that some other matters also as may be prescribed. As may be prescribed, wherever this word has been written, when you find out the meaning of the prescribed, section 2 subsection 66, it says prescribed mean as framed under the rule made by the government under this particular act. So as per the rule made, if the rule in this respect the central government has framed, and there they have directed that these 5 things or 4 things also has to be included in the memorandum, so that has to be also included. And then also it would not be that conclusive that only those matter will remain there, because section 5 subsection 1 says that it shall have the regulation of management without referring that what exactly it will have. So any matter relating to the management, any matter that the company think it related to management will be included, that even if you not find under the rule prescribed, or you have not find under the model आर्टिकल्स अंडर द डिफरेंट टेबल, वो रूल भी आप इसमें डाल सकते हो. यस रंजन, प्लीज रीड 5 सबसेक्शन 2. यस.
Subsection 2. The article shall contain such matters as may be prescribed, provided that nothing prescribed in the subsection shall be deemed to prevent a company from including such additional matters in its articles as may be considered necessary for its management.
Yes. So this is clear what I have explained, that this articles, that is a document with respect to the regulation for management of the company, shall also contain the matters as the central government with time to time through the rules has prescribed, that ये भी आपको डालना है, ये भी डालना है. And second is by way of clarification this proviso, that provided nothing prescribed in this subsection shall be deemed to prevent a company from including additional matter. So whatever we have understand, that anything we can put as a management. Okay, so here also just the people will not get confused by the wording of subclause 2, that whether this articles of association will include only those matters that has been prescribed. Proviso is clearing no, any additional matter can also be put under it. Okay, now there is a third thing, that nothing is permanent here, everything is subject to change. The only permanent thing is here is the change. And so whatever or how meticulously you have framed the articles of association. You have put every detail with the management. Maybe in the future it is needed to change it. Okay, so how it will be changed? There is a procedure that according it to it has to be changed, and the procedure is under the section 14, the alteration of the articles. So accordingly it have to be changed. Whatever the majority it is required, you can compare it with our constitution. Look, we have the constitution, very good document, everyone is appreciating, supreme court have many judgment appreciated, हम भी उसको appreciate करते हैं. But then also our constituent assembly thought that maybe in the future it is needed, and that we have witnessed also so many amendment has been made. Okay, so the article 368 is there, and article 368 make our constitution as an organic document, organic, like recording. Recording is not the option I am doing with my mobile phone, keeping with me. Okay, here I did not get recording, so sorry for that. Okay, Manik, पता नहीं it has not been provided by the Google Classroom. पता चल गया होगा कि record कर रहे हैं. Okay, so yes, and so we call our constitution as organic document because it will change with the time. Okay, and then the procedure is there. Similarly, here is the procedure for alteration of the memorandum section 13 and alteration of article section 14. Suppose you want to make a certain provisions that whose change would be much difficult. Okay, like in under article 368, one is that you can change with the special majority, and then whenever we want to change the provisions that relating to the state center state relationship, for that with special majority what is required, क्या होता है, स्पेशल मेजॉरिटी चाहिए कॉन्स्टिट्यूशन में अमेंडमेंट के लिए. और अगर हम ऐसे प्रोविज़न को हम अमेंड कर रहे हैं जो फेडरल स्ट्रक्चर को अफेक्ट करते हैं, तो उसमें विद स्पेशल मेजॉरिटी व्हाट वी रिक्वायर्ड, consent of half of the states. So that is means for some provision it is special majority, for other or rest of the provision the procedure is much difficult. And this type of the thing where we say that it is much difficult, in the technical term we call it an entrenchment. क्या बोलते हैं? Entrenchment. So that is known as entrenchment. And for that, in the articles of the association itself, you can make the entrenchment clause also. That similar, for other clauses the amendment will be as per the article 14, but these are the certain provision for that amendment will be as per this method as we have written. So this is entrenchment, making a provision difficult to amend or providing a special procedure is known as entrenchment. Yes, please read section 5 clause 3. 5 subsection 3.
Clause 3. The articles may contain provisions for entrenchment to the effect that specified provisions of the articles may be altered only if conditions or procedures as that are more restrictive than those applicable in the case of a special resolution are made or complied with.
Yeah, so I think it's clear, no need to more explanation, that entrenchment provision can be made in articles and procedure has to be mentioned, and accordingly that particular provision will be amended. Okay, now read 5 subsection 4.
The provisions for entrenchment referred to in subsection 3 shall only be made either on formation of a company or by an amendment in the articles agreed to by all the members of the company in the case of a private company, and by a special resolution in the case of public company.
Yes, now see, here is the catch, that suppose there is an entrenchment procedure where or you can say, you can compare it, that article 368 gives the power to amend the constitution. Okay, so constitution means every provision of the constitution. Even the preamble can be amended, as it was held in the Inre Verubari case. The Supreme Court held that the preamble is also the part of the constitution and it can be amended. Similarly, if someone asks that can the parliament amend in article 368 itself by using the power of article 368, so here it's saying that entrenchment make certain provisions amendment in the articles difficult. Suppose at the inception, when the company was formed, there was no entrenchment, or there was entrenchment with respect to certain provision, and then company want to add some entrenchment provision in it. So that entrenchment, whether it would be like the similar things as prescribed under section 14, that means the simple procedure for the alteration, or it would be difficult or a complex procedure. Subclause 4 here saying that in that respect, if the entrenchment clause want to be put in the articles, then in case of the private company, it would be through all the members, that by an amendment to the article agreed by all the members, and in case of the company, through the special resolution. And the special resolution you will read under section 115 of the Companies Act. There the special resolution is difficult. The special resolution here is that if there is any vote against the motion, then the number of vote in the favor must be greater than the number of vote against the that motion. So that is the requirement. More you can read with those provisions. Okay, now read next subsection. These 3 subsections are with respect to the entrenchment. Okay, and these are very important. When you read alteration, you also have to see the entrenchment provision in the articles, because these entrenchment provision have the effect, the overriding effect on the section 14 of the Companies Act. So okay, so very important. Please read the next. Ranjan want to ask something.
So in the private company, as it is mentioned here, that it should be agreed by all the members. But in public, there should be only majority, right?
See, the justification is that in the private company the members are limited, but in in case of public company, the members so maybe in the large number, and so that would be very much difficult, because at least maybe 2-3 members would not agree even on that. And just to make that much practicable, they have put the special majority, because special majority in itself is a difficult procedure. Whenever there is the special majority, that means if there is any vote against it, that means the vote can be against it, but the number of vote against the that proposal should be less than 1/3 of the in favor of the proposal. So that's only the justification, because large number of person are in the private public companies. Okay.
Yes.
Okay, read clause 5.
Section 5. Where the articles contain provisions for entrenchment, whether made on formation or by amendment, the company shall give notice to the registrar of such provisions in such form and manner as may be prescribed.
Yes, so suppose a company want to contain the provision of entrenchment either at the time of formation like this, or by the amendment. In the both case, the registrar of the company shall be informed, and the purpose of that information to the registrar is that the Generally, if you will not inform it, then the registrar will think that these are the general the regulation for the management, but the effect of the entrenchment is that it will override the section 14. And so in case of this type of the difficulty, etc., it's needed that at the inception or when you are making such type of the entrenchment provision, this should be also in the public domain, registered with the registrar of the company, so that if there is any issue of getting effect of the alteration, that would be maybe perfectly valid as per section 14, but because for that particular regulation or provision in the articles there is the entrenchment, and accordingly that procedure has not been followed, so in effect the amendment will not commit. And so it's always mandatory to file that this is the entrenchment to the registrar, so that the registrar also note it down. Okay. Now there is one question that generally student ask, that's are these articles of the association talking about that these are the matters that we have to prescribe or entrenchment, etc., whether it is applicable to a new company or is it applicable to all other company that have been already registered, because Companies Act 2013 are applicable to the companies incorporated under 2013 Act or under previous legislation also. To the previous legislation, whether these articles of the association will be applicable, because if it will be applicable, then they have also to comply with it. Okay. And answer lies in section 5 subsection 9, where says to the previous companies it has not been applied, but if they want to amend now, then they have to amend as per the section 5. Yes, read 5 subsection 9.
Section 5, nothing in this section shall apply to the articles of a company registered under any previous company law unless amended under this Act.
Yes. Now come to the those table that I have referring, that those table in the schedule first will be applicable. So those applicability is under section 5 subsection 6, that the article of the company shall be in respective form specified in table F, G, H, I, J in the schedule I as may be applicable to the company. So that is the model table, accordingly you have to form, and these table are with respect to the different types of the company, like the private company, the company with share capital, company with not having the share capital, etc. So whatever format is applicable to your company, you can choose it. The very purpose is that so that these matters will be as per their you can say sequence, or the person would not miss out all of these materials. Even other also can be added in these model tables also. So please read this section 6 subsection 6 and then subsection 7.
Subsection 6. The articles of a company shall be in respective forms specified in tables G, H, I, and J in Schedule I as may be applicable to such company. Subsection 7. A company may adopt all or any of the regulations contained in the model articles applicable to such company.
Yeah. So clause 7 is saying, 6 is saying that you can adopt that the model that is applicable to your company, and in that model also it's not mandatory that you have to have only those conditions, and you have to make your regulation with respect to, you can adopt all or any of these. But then there is the difficulty, that what would be the effect if you are written some condition, but you have not rejected that we are not making regulation on these issues, and on this your answer will you will find in the subclause 8. Just please read subclause 8 also.
Suppose 8. In case of any company which is registered after the commencement of this Act, in so far as the registered articles of such company do not exclude or modify the regulations contained in the model articles applicable to such company, those regulations shall, so far as applicable, be the regulations of that company in the same manner and to the extent as if they were contained in the duly registered articles of the company.
Yes. So if company do not exclude or modify the regulation contained in the model article, either you have to modify that this rule will not be like the director will not be 5 but the 6, okay, or the procedure of voting will not be this but that, or you have to exclude it. Otherwise the effect would be that so far as applicable be the regulation of that company in the same manner as to the same extent that they have been contained in the duly registered articles of the company. So even if you have not written but you have not even excluded, automatically all the model article will be applicable, okay. And this thing is made with the purpose, like similar thing we find under the uh, partnership act. In the partnership act there would be clauses save or accept as the partners will make through the agreement. This would be the law. So that means the law is there but the partners can change, can make, and if they are making then this law will not be applicable, rather their law will be applicable. Similar thing we will find under the Hindu Marriage Act 1950. I just making a corollary, okay, example is there, exactly not same. In the Hindu Marriage Act also, like with the spinda relationship or with the prohibited relationship, there is the scope for the custom. If the custom allows, then otherwise can be done, okay. So similarly, either you have to exclude that no, this will not apply, we will have this type of the regulation, otherwise these regulation will automatically will apply. So at least the company will have this much of the regulation for the management. That means this is the law and accordingly that has to be decided. Now come to the table, so that quickly we can see one table also, and you will be एफ भी देख लेते हैं. यस, see this is a table, and table F, the articles of association of a company limited by share, okay. So this would be there, wherever you want to make the changes you can make the changes in it, otherwise it will apply as per to the against the all the members and the company, that these are the rules for the regulation of the management, okay. Interpretation, then share capital and variation of rights, then there is lien, then there is call on the shares, then there are the transfer of shares, rule relating to transfer of shares, transmission of shares, and then forfeiture of shares. So different regulation you will find with different matters of the company that company has to observe or see in his day-to-day working, and this is about the articles of the association. So here we will discuss that what are the matters that we have to include in the articles of the association, or the format. And here we have learned that all the matters that have been prescribed in different table, we can choose those or we can exclude or modify any of them. But if we forget to modify or expressly exclude, then the law will treat that all those regulation will be applicable. These regulation are also not the conclusive. Even through the rule making power, the government with time to time also make certain new regulation, but those regulation will be applicable when either you form a company after the coming of those rules, or you are amending your articles after coming of those rules. Otherwise, when you form the company and in the new time or after that some new rules came, you have not to comply with that in your earlier, but when you will amend your articles, you have to comply with that. Then the provisions of the entrenchment, that means you can provide a specific procedure for amendment, making amendment in the articles with respect to certain regulations in the articles, and that will override with section 14, and accordingly amendment would be possible. That entrenchment also you have to inform to the registrar. Now the second thing is about the effect of the articles. The effect of the articles, quickly we can see, because earlier also in yesterday class we have discussed that section 10 of the Companies Act talking about the effect of the the memorandum and the articles. That means the section 10 is applicable both for the memorandum as well as for the articles of the association, and it says that subject to the provision of this act. Subject to the provision of this act means if somewhere the provisions say something else, then that would be apply. Okay, so that provision will start with notwithstanding. So other provision that putting some other condition will be non-obstante clause, and this section 10 is the subjection clause. These are the terminology we use while read the statute, or you will read under the subject interpretation of the statute. So memorandum and subject to the provision of this act, I am reading section 10. Subject to the provision of this act, the memorandum and articles shall, when registered, bind the company and member thereof to the same extent that if they respectively had been signed by the company and by each members, and contain covenant on its part to observe all the provisions of the memorandum and of the article. And so the effect would be that the company and in the member there was a contract with respect to that. So that would be effect. Okay, now the third thing that is this binding nature, that they are binding and you cannot say escape from the bindingness of this particular articles or the regulation that put there. Now the next will be alteration. Alteration to the memorandum, alteration in the articles of association. For the alteration in the memorandum, we have section 13. Yes. Here for the alteration of memorandum, that means we want to read alteration in name clause, alteration in registered office clause, alteration in object clause, alteration in liability clause, alteration in share capital, whether share capital can be increased or not. And this particular provision is start with except with section 61, that talking about some share capital with respect to a particular company. So we are not going first into the section 61. Later on we will discuss that what section 61 is saying. So leave this portion save as provided in 61. You have to read a company may. Yes, please.
A company may, by a special resolution and after complying with the procedure specified in the section, alter the provisions of its memorandum.
So this is a general provision that is applicable to every section, that through the special provision alteration is possible. And here we have learned two things. First is the alteration, or you can say amendment, that whether the amendment in the memorandum is possible or not. You know how beautiful name you have put. even you think you can think this thing with your name also. Many time we think ki our name should be not like this but some other name, and generally your words, आपके बच्चे होते हैं वो ज़्यादा सोचते हैं इस बारे में कि कि it would be better that if our name would be not this but that. Okay, and so whatever name you have put, maybe at the point of time you want to change it because it became irrelevant or otherwise. Maybe whatever object you have meticulously put, but in that object it would not be possible to have do the business, and just to do that also you can want to make the change. You have put your registered office in the in महाराष्ट्र, और फिर बाद में पता चला कि महाराष्ट्र में तो वो बोले कि मराठी मानुस चाहिए, तो आपको बड़ा डर लगा, यू वांट टू शिफ्ट योर ऑफिस टू दिल्ली. So whatever may be the reason, but it's sure that change is needed, and this section 13 is talking about that change. So first clause talks two things. One is change is possible, and second is the procedure. So for change, yes, it is possible. For the procedure, it is special majority. Section 114 read with 115 talking about special resolution. Section 114, is it visible to your screen? Yeah, a resolution, I'm reading section 114 subsection 2 and then 115 also, that make the whole procedure of special resolution. Section 114 subsection 1 is about ordinary resolution. So section 114 subsection 2 says a resolution shall be by special resolution. A resolution shall be a special resolution when first the intention to propose the resolution as a special resolution has been duly specified in the notice calling the general meeting or other intimation given to the member. So first thing, that whenever, because the resolution will be passed by the members, and to the members you will give the notice, then the members will come. Otherwise how the members will know that there would be some meeting? And for that, in the notice itself you have to mention about that we want to make a special resolution. Then clause B, that the notice required under this act has been duly given. Duly given means as per that how many days you have to give the notice. Okay, before how many days you have to give the notice. And the third one, that is about the number of the voting. That important, as I said, that the vote cast in favor of resolution, whether on show of hand or electronically or by poll as the case may be, किसी भी तरह के से वोटिंग हो, लेकिन वोट कास्ट इन फेवर ऑफ रेजोल्यूशन, who is entitled to do vote in person or proxy, postal, etc. These are the different method. So the vote cast in favor of resolution are required to be not less than the 3 times of vote, if any, cast against the resolution by the members so entitled and the voting. So there are two possibility, that if resolution is moved that we want to make or amend the name of the company from Raju Electricals to Rajeshwar Electricals, then either that all members say yes, 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 ये तो बहुत रेयर होता है, so in that say yes, it will be done. Or if some members say yes and some members say no, in that case we have to see that the number of voting in favor of the company should not be less than 3 times number of the vote in favor. Suppose there are 10 votes, okay, 10 votes. So if 2 votes are against and 8 votes are in favor of the resolution, then yes, because 8 is more than इक्वल और मोर देन 3 times ऑफ द 2. 3 times 2 का करेंगे तो 6. तो ये, बट सपोज the 3 vote are against, okay, then what number of votes you want to required for special resolution? 3 times or more than 3 times, because it's saying not less than 3, so 3 or more than 3, so 9 vote you required and totally vote 10 है. 3 इसमें ले गए तो 7 ही आपके पास रहेगा और आपका वो जो मोशन है that would be defeated. Okay, have you got this procedure? It's very simple. समझ में आया? Okay, and then you have to read section 115 also, because that talking about special notice, that also you have to read. Please read yourself at your home. I'm not going to read it. Okay, now come again to our section 13 that we were discussing about the the procedure, and here saying the second subsection is that about the specific. Now the different subsection under section 13 are with respect to the different clauses. Okay, as a general special majority, but with respect to some clauses there are some different requirement also along with this special majority. Special majority तो चाहिए, उसके साथ हर क्लोज की कुछ अलग रिक्वायरमेंट भी है. that has been written in these subsections. So the first one is with respect to the name clause. Yes, read 13 subsection 2.
13 subsection 2. Any change in the name of a company shall be subject to the provisions of the subsections 2 and 3 of the section 4 and shall not have effect except with the approval of the central government in writing, provided that no such approval shall be necessary where the only change in the name of the company is the deletion therefrom or addition thereto of the word private consequent on the conversion of any one class of the companies to the another class in accordance with the provisions of this act.
Yeah, thank you, Ranjan. So this is saying that just to making the coherence in the law, that section 13 subsection 1 is allowing that through the amendment one can make the changes in the memorandum, and change in the memorandum means memorandum में वो 5 चीज़ें रहती हैं. Okay, so name clause और उनमें change कर सकते हो, and so it would give the impression that you can make the changes through the special resolution. Even you can surpass what is written there in the section 4 subsection 2 or 4 subsection 3. Any previous name registered you can put by special resolution. And just to make it clear, this thing has been written that it does not understood in same manner, and that's why it's saying that the name clause, the change in the name of the company shall be subject to the provision of subsection 2 and the 3. That is also from somewhere also we can take the inference, but this is the best way as a way of precaution to making the law or the effect of the particular thing not to go incoherently. So whatever the name you want to make, और for that you want to you pass the special resolution also, पहले वो name तो देख लो, क्या वो name section 4 subsection 2 से hit कर रहा है. That means already that name, with that name a company is registered, or some company have the trademark, they will get the criminal action against you. Okay, or maybe that is inappropriate. Okay, this type of the thing. So that, and the second thing is the permission, that accept with the approval of the central government in writing, and this approval has two purposes. The first purpose is that when the company is registered, it having the business, and these companies, because many cheating thing will happen in the company corporate world, so maybe by changing the name it will get confusion in the society. So the central government will take care about that also, because government is like our parents. Uh, the second thing is that the governments will see thoroughly that whether any prior name has been taken or not, and then the section 16 will also they can apply, they can make or ask for any rectification if they found. Okay, so that is the purpose of the section 13 subsection 2. बट सपोज देर इज अ चेंज ओनली विद द प्राइवेट, पहले आपकी पब्लिक कंपनी थी, यू कन्वर्ट इट इन ए प्राइवेट कंपनी, दैट कन्वर्जन इज पॉसिबल. देर आर मैनी प्रोविजन्स, यू विल रीड इट, to changing the public company to private to share capital. So in that consequence the only change is that the private you have to add. अब प्राइवेट ऐड करना, उसके लिए क्या स्टेट से परमिशन और क्या वो लेना है, दैट इज जस्ट द रिक्वायरमेंट एज पर द सेक्शन 4(1)(a), name of the company, then public and private, limited and private limited, as per the your company is limited or the private limited. So if that change is then there is no need of the permission, because in that case the central government will not give the second opinion. That is the requirement of the law, you have to comply with it. Okay, now go to the, I think we have exceeded with the time, so I stop here, and the rest of the amendment, or you can say alteration in the memorandum, we will done in the next class, and then we will done along with that the memorandum in the articles of the association, and then this topic will be over. We will then move to the doctrine of ultra vires, and then the cases, etc. Okay, so guys, with this today class is over. If you have any question, any query, you can post me on through your CR at my WhatsApp number.